Civil Code. Article 1732. Common carriers are persons, corporations, firms, or associations engaged in the business of carrying or transporting passengers or goods or both, by land, water, or air, for compensation, offering their services to the public. Article 1755. A common carrier is bound to carry the passengers safely as far as human care and foresight can provide, using the utmost diligence of very cautious persons, with a due regard for all the circumstances. Article 1756. In case of death of or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently, unless they prove that they observed extraordinary diligence, as prescribed in Articles 1733 and 1755. Article 1767. By the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund, with the intention of dividing the profits among themselves. Two or more persons may also form a partnership for the exercise of a profession. Article 1813. A conveyance by a partner of his whole interest in the partnership does not of itself dissolve the partnership, or, as against the other partners in the absence of agreement, entitle the assignee, during the continuance of the partnership, to interfere in the management or administration of the partnership business or affairs, or to require any information or account of partnership transactions, or to inspect the partnership books, but it merely entitles the assignee to receive in accordance with his contract the profits to which the assigning partner would otherwise be entitled. However, in case of fraud in the management of the partnership, the assignee may avail himself of the usual remedies. In case of a dissolution of the partnership, the assignee is entitled to receive his assignor's interest and may require an account from the date only of the last account agreed to by all the partners. Article 1829. On dissolution, the partnership is not terminated, but continues until the winding up of partnership affairs is completed. Article 1835. The dissolution of the partnership does not of itself discharge the existing liability of any partner. A partner is discharged from any existing liability upon dissolution of the partnership by an agreement to that effect between himself, the partnership creditor, and the person or partnership continuing the business, and such agreement may be inferred from the course of dealing between the creditor having knowledge of the dissolution and the person or partnership continuing the business. The individual property of a deceased partner shall be liable for all obligations of the partnership incurred while he was a partner, but subject to the prior payment of his separate debts. Revised Corporation Code. Section 2. Corporation defined. A corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incidental to its existence. Section 10. Number and qualifications of incorporators. Any person, partnership, association, or corporation, singly or jointly with others, but not more than 15 in number, may organize a corporation for any lawful purpose or purposes, provided that natural persons who are licensed to practice a profession and partnerships or associations organized for the purpose of practicing a profession shall not be allowed to organize as a corporation unless otherwise provided under special laws. Incorporators who are natural persons must be of legal age. Each incorporator of a stock corporation must own or be a subscriber to at least one share of the capital stock. A corporation with a single stockholder is considered a one-person corporation as described in Title 13, Chapter 3 of this code. Section 11. Corporate term. A corporation shall have perpetual existence unless its articles of incorporation provides otherwise. Section 24. Corporate officers. Immediately after their election, the directors of a corporation must formally organize and elect a president, who must be a director. B. A treasurer, who must be a resident. C. A secretary, who must be a citizen and resident of the Philippines. And D. Such other officers as may be provided in the bylaws. If the corporation is vested with public interest, the board shall also elect compliance officer. The same person may hold 2 or more positions concurrently, except that no one shall act as president and secretary or as president and treasurer at the same time, unless otherwise allowed in this code. The officers shall manage the corporation and perform such duties as may be provided in the bylaws and/or as resolved by the board of directors. Section 30. Liability of directors, trustees, or officers. Directors or trustees who willfully and knowingly vote for or assent to patently unlawful acts of the corporation or who are guilty of gross negligence or bad faith in directing the affairs of the corporation or acquire any personal or pecuniary interest in conflict with their duty as such directors or trustees shall be liable jointly and severally for all damages resulting therefrom suffered by the corporation, its stockholders or members and other persons. A director, trustee, or officer shall not attempt to acquire, or any interest adverse to the corporation in respect of any matter which has been reposed in them in confidence, and upon which equity imposes a disability upon themselves to deal in their own behalf. Otherwise, the said director, trustee, or officer shall be liable as a trustee for the corporation and must account for the profits which otherwise would have accrued to the corporation. Section 31. Dealings of directors, trustees, or officers with the corporation. A contract of the corporation with one or more of its directors, trustees, officers, or their spouses and relatives within the 4th civil degree of consanguinity or affinity is voidable, at the option of such corporation, unless all the following conditions are present. A. The presence of such director or trustee in the board meeting in which the contract was approved was not necessary to constitute a quorum for such meeting. B. The vote of such director or trustee was not necessary for the approval of the contract. C. The contract is fair and reasonable under the circumstances. D. In case of corporations vested with public interest, material contracts are approved by at least a majority of the independent directors voting to approve the material contract. And E. In case of an officer, the contract has been previously authorized by the board of directors. Where any of the first 3 conditions set forth in the preceding paragraph is absent, in the case of a contract with a director or trustee, such contract may be ratified by the vote of the stockholders representing at least 2/3 of the outstanding capital stock or of at least 2/3 of the members in a meeting called for the purpose, provided that full disclosure of the adverse interest of the directors or trustees involved is made at such meeting and the contract is fair and reasonable under the circumstances. Section 35. Corporate powers and capacity. Every corporation incorporated under this code has the power and capacity: A. To sue and be sued in its corporate name. B. To have perpetual existence unless the certificate of incorporation provides otherwise. C. To adopt and use a corporate seal. D. To amend its articles of incorporation in accordance with the provisions of this code. E. To adopt bylaws, not contrary to law, morals, or public policy, and to amend or repeal the same in accordance with this code. F. In case of stock corporations, to issue or sell stocks to subscribers and to sell treasury stocks in accordance with the provisions of this code, and to admit members to the corporation if it be a non-stock corporation. G. To purchase, receive, take or grant, hold, convey, sell, lease, pledge, mortgage, and otherwise deal with such real and personal property, including securities and bonds of other corporations, as the transaction of the lawful business of the corporation may reasonably and necessarily require, subject to the limitations prescribed by law and the Constitution. H. To enter into a partnership, joint venture, merger, consolidation, or any other commercial agreement with natural and juridical persons. To make reasonable donations, including those for the public welfare or for hospital, charitable, cultural, scientific, civic, or similar purposes, provided that no foreign corporation shall give donations in aid of any political party or candidate or for purposes of partisan political activity. J. To establish pension, retirement, and other plans for the benefit of its directors, trustees, officers, and employees, and K. To exercise such other powers as may be essential or necessary to carry out its purpose or purposes as stated in the Articles of Incorporation. Section 38. Power to deny preemptive right. All stockholders of a stock corporation shall enjoy preemptive right to subscribe to all issues or disposition of shares of any class in proportion to their respective shareholdings, unless such right is denied by the Articles of Incorporation or an amendment thereto, provided that such preemptive right shall not extend to shares issued in compliance with laws requiring stock offerings or minimum stock ownership by the public, or to shares issued in good faith with the approval of the stockholders representing 2/3 of the outstanding capital stock in exchange for property needed for corporate purposes or in payment of previously contracted debt. Section 42. Power to declare dividends. The board of directors of a stock corporation may declare dividends out of the unrestricted retained earnings which shall be payable in cash, property, or in stock to all stockholders on the basis of outstanding stock held by them, provided that any cash dividends due on delinquent stock shall first be applied to the unpaid balance on the subscription plus costs and expenses, while stockholders until their unpaid subscription is fully paid, provided, further, that no stock dividend shall be issued without the approval of stockholders representing at least 2/3 of the outstanding capital stock at a regular or special meeting duly called for the purpose. Stock corporations are prohibited from restraining surplus profits in excess of 100% of their paid-in capital stock, except a. When justified by the definite corporate expansion projects or programs approved by the board of directors, or b. When the corporation is prohibited under any loan agreement with financial institutions or creditors, whether local or foreign, from declaring dividends without their consent, and such consent has not yet been secured, or c. When it can be clearly shown that such retention is necessary under special circumstances obtaining in the corporation, such as when there is need for special reserve for probable contingencies. Section 64. Liability of directors for watered stocks. A director or officer of a corporation who a. consents to the issuance of stocks for a consideration less than its par or issued value, b. consents to the issuance of stocks for the consideration other than cash, valued in excess of its fair value, or c. having knowledge of the insufficient consideration, does not file written objection with the corporate secretary, shall be liable to the corporation or its creditors, solidarily with the stockholder concerned for the difference between the value received at the time of issuance of the stock and the par or issued value of the same. The Insurance Code. Section 2. Whenever used in this code, the following terms shall have the respective meanings hereinafter set forth or indicated, unless the context otherwise requires. A contract of insurance is an agreement whereby one undertakes for a consideration to indemnify another against loss, damage, or liability arising from an unknown or contingent event. A contract of suretyship shall be deemed to be an insurance contract, within the meaning of this code, only if made by a surety who or which, as such, is doing an insurance business as hereinafter provided. B. The term doing an insurance business or transacting an insurance business, within the meaning of this code, shall include 1. making or proposing to make, as insurer, any insurance contract. 2. Making or proposing to make, as surety, any contract of suretyship as a vocation and not as merely incidental to any other legitimate business or activity of the surety. 3. Doing any kind of business, including a reinsurance business, specifically recognized as constituting the doing of an insurance business within the meaning of this code. 4. Doing or proposing to do any business in substance equivalent to any of the foregoing in a manner designed to evade the provisions of this code. In the application of the provisions of this code, the fact that no profit is derived from the making of insurance contracts, agreements, or transactions, or that no separate or direct consideration is received therefore, shall not be deemed conclusive to show that the making thereof does not constitute the doing or transacting of an insurance business. C. As used in this code, the term commissioner means the insurance commissioner. Section 10. Every person has an insurable interest in the life and health. A. Of himself, of his spouse, and of his children. B. Of any person on whom he depends wholly or in part for education or support, or in whom he has a pecuniary interest. C. Of any person under a legal obligation to him for the payment of money, or respecting property or services, of which death or illness might delay or prevent the performance. And D. Of any person upon whose life any estate or interest vested in him depends. Section 13. Every interest in property, whether real or personal, or any relation thereto, or liability in respect thereof, of such nature that a contemplated peril might directly damnify the insured, is an insurable interest. Section 14. An insurable interest in property may consist in A. An existing interest. B. An inchoate interest founded on an existing interest. Or C. An expectancy coupled with an existing interest in that out of which the expectancy arises. Section 48. Whenever a right to rescind a contract of insurance is given to the insurer by any provision of this chapter, such right must be exercised previous to the commencement of an action on the contract. After a policy of life insurance made payable on the death of the insured shall have been enforced during the lifetime of the insured for a period of 2 years from the date of its issue or of its last reinstatement, the insurer cannot prove that the policy is void ab initio or is rescindable by reason of the fraudulent concealment or misrepresentation of the insured or his agent. Section 64. No policy of insurance other than life shall be cancelled by the insurer except upon prior notice thereof to the insured, and no notice of cancellation shall be effective unless it is based on the occurrence, after the effective date of the policy, of one or more of the following. A. Non-payment of premium. B. Conviction of a crime arising out of acts increasing the hazard insured against. C. Discovery of fraud or material misrepresentation. D. Discovery of willful or reckless acts or omissions increasing the hazard insured against. E. Physical changes in the property insured which result in the property becoming uninsurable. F. Discovery of other insurance coverage that makes the total insurance in excess of the value of the property insured. Or G. A determination by the Commissioner that the continuation of the policy would violate or would place the insurer in violation of this code. Section 93. Delay in the presentation to an insurer of notice or proof of loss is waived if caused by any act of him, or if he omits to take objection promptly and specifically upon that ground. Section 94. If the policy requires, by way of preliminary proof of loss, the certificate or testimony of a person other than the insured, it is sufficient for the insured to use reasonable diligence to procure it, and in case of the refusal of such person to give it, then to furnish reasonable evidence to the insurer that such refusal was not induced by any just grounds of disbelief in the facts necessary to be certified or testified. Section 124. If the course of sailing is not fixed by mercantile usage, The voyage insured by a marine insurance policy is that way between the places specified, which to a master of ordinary skill and discretion would mean the most natural, direct, and advantageous. Section 139. An insurance confined in terms to an actual loss does not cover a constructive total loss, but covers any loss, which necessarily results in depriving the insured of the possession, at the port of destination, of the entire thing insured. Intellectual Property Code. Section 21. Patentable inventions. Any technical solution of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable shall be patentable. It may be, or may relate to, a product or process, or an improvement of any of the foregoing. Section 30. Inventions created pursuant to a commission. 30.1. The person who commissions the work shall own the patent, unless otherwise provided in the contract. 30.2. In case the employee made the invention in the course of his employment contract, the patent shall belong to a. the employee, if the inventive activity is not a part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. B. The employer, if the invention is the result of the performance of his regularly assigned duties, unless there is an agreement, express or implied, to the contrary. Section 122. How marks are acquired. The rights in a mark shall be acquired through registration made validly in accordance with the provisions of this law. Section 172. Literary and artistic works. 172.1. Literary and artistic works, hereinafter referred to as works, are original intellectual creations in the literary and artistic domain protected from the moment of their creation, and shall include in particular a. Books, pamphlets, articles, and other writings. B. Periodicals and newspapers. C. Lectures, sermons, addresses, dissertations prepared for oral delivery, whether or not reduced in writing or other material form. D. Letters. E. Dramatic or dramatico-musical compositions, choreographic works, or entertainment in dumb shows. F. Musical compositions, with or without words. G. Works of drawing, painting, architecture, sculpture, engraving, lithography, or other works of art, models or designs for works of art. H. Original ornamental designs or models for articles of manufacture, whether or not registrable as an industrial design, and other works of applied art. 1. Illustrations, maps, plans, sketches, charts, and three-dimensional works relative to geography, topography, architecture, or science. J. Drawings or plastic works of a scientific or technical character. K. Photographic works, including works produced by a process analogous to photography, lantern slides. L. Audiovisual works and cinematographic works, and works produced by a process analogous to cinematography or any process for making audiovisual recordings. M. Pictorial illustrations and advertisements. N. Computer programs, and O. Other literary, scholarly, scientific, and artistic works. 172.2. Works are protected by the sole fact of their creation, irrespective of their mode or form of expression, as well as of their content, quality, and purpose. Section 178. Rules on copyright ownership. Copyright ownership shall be governed by the following rules. 178.1. Subject to the provisions of this section, in the case of original literary and artistic works, copyright shall belong to the author of the work. 178.2. In the case of works of joint authorship, the co-authors shall be the original owners of the copyright, and in the absence of agreement, their rights shall be governed by the rules on co-ownership. If, however, A work of joint authorship consists of parts that can be used separately, and the author of each part can be identified. The author of each part shall be the original owner of the copyright in the part that he has created. 178.3. In the case of work created by an author during and in the course of his employment, the copyright shall belong to a. the employee, if the creation of the object of copyright is not a part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. B. The employer, if the work is the result of the performance of his regularly assigned duties, unless there is an agreement, express or implied, to the contrary. 178.4. In the case of a work commissioned by a person other than an employer of the author and who pays for it, and the work is made in pursuance of the commission, the person who so commissioned the work shall have ownership of the work, but the copyright thereto shall remain with the creator, unless there is a written stipulation to the contrary. Section 184. Limitations on copyright. 184.1. Notwithstanding the provisions of Chapter 5, the following acts shall not constitute infringement of copyright. A. The recitation or performance of a work, once it has been lawfully made accessible to the public, if done privately and free of charge, or if made strictly for a charitable or religious institution or society. B. The making of quotations from a published work if they are compatible with fair use, and only to the extent justified for the purpose, including quotations from newspaper articles and periodicals in the form of press summaries, provided that the source and the name of the author, if appearing on the work, are mentioned. C. The reproduction or communication to the public by mass media of articles on current political, social, economic, scientific, or religious topic, lectures, addresses, and other works of the same nature, which are delivered in public if such use is for information purposes and has not been expressly reserved, provided that the source is clearly indicated. D. The reproduction and communication to the public of literary, scientific, or artistic works as part of reports of current events by means of photography, cinematography, or broadcasting to the extent necessary for the purpose. E. The inclusion of a work in a publication, broadcast, or other communication to the public, sound recording, or film, if such inclusion is made by way of illustration for teaching purposes and is compatible with fair use, provided that the source and the name of the author, if appearing in the work, are mentioned. F. The recording made in schools, universities, or educational institutions of a work included in a broadcast for the use of such schools, universities, or educational institutions, provided that such recording must be deleted within a reasonable period after they were first broadcast, provided, further, that such recording may not be made from audiovisual works, which are part of the general cinema repertoire of feature films except for brief excerpts of the work. G. The making of ephemeral recordings by a broadcasting organization by means of its own facilities and for use in its own broadcast. H. The use made of a work by or under the direction or control of the government, by the National Library, or by educational, scientific, or professional institutions where such use is in the public interest and is compatible with fair use. 1. The public performance or the communication to the public of a work, in a place where no admission fee is charged in respect of such public performance or communication, by a club or institution for charitable or educational purpose only, whose aim is not profit-making, subject to such other limitations as may be provided in the regulations. J. Public display of the original or a copy of the work not made by means of a film, slide, television image, or otherwise on screen, or by means of any other device or process, provided that either the work has been published or that the original or the copy displayed has been sold, given away, or otherwise transferred to another person by the author or his successor in title, and K. Any use made of a work for the purpose of any judicial proceedings or for the giving of professional advice by a legal practitioner. Section 185. Fair use of a copyrighted work. 185.1. The fair use of a copyrighted work for criticism, comment, news reporting, teaching including multiple copies for classroom use, scholarship, research, and similar purposes is not an infringement of copyright. Decompilation, which is understood here to be the reproduction of the code and translation of the forms of the computer program to achieve the interoperability of an independently created computer program with other programs, may also constitute fair use. In determining whether the use made of a work in any particular case is fair use, the factors to be considered shall include: A. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. B. The nature of the copyrighted work. C. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And D. The effect of the use upon the potential market for or value of the copyrighted work. The new Central Bank Act. Sector 30. Proceedings in receivership and liquidation. Whenever, upon report of the head of the supervising or examining department, the Monetary Board finds that a bank or quasi-bank A. has notified the Banco Central or publicly announced a unilateral closure, or has been dormant for at least 60 days, or in any manner has suspended the payment of its deposit/deposit substitute liabilities, or is unable to pay its liabilities as they become due in the ordinary course of business, provided that this shall not include inability to pay caused by extraordinary demands induced by financial panic in the banking community. B. Has insufficient realizable assets, as determined by the Banco Central, to meet its liabilities, or C. Cannot continue in business without involving probable losses to its depositors or creditors, or D. Has willfully violated a cease and desist order under Section 37 of this Act that has become final, involving acts or transactions which amount to fraud or a dissipation of the assets of the institution, in which cases the Monetary Board may summarily, and without need for prior hearing, forbid the institution from doing business in the Philippines and designate the Philippine Deposit Insurance Corporation as receiver in the case of banks, and direct the PDIC to proceed with the liquidation of the closed bank pursuant to this section and the relevant provisions of Republic Act No. 3591, as amended. The Monetary Board shall notify in writing, through the receiver, the Board of Directors of the closed bank of its decision. The actions of the Monetary Board taken under this section or under Section 29 of this Act shall be final and executory and may not be restrained or set aside by the court except on petition for certiorari on the ground that the action taken was in excess of jurisdiction or with such grave abuse of discretion as to amount to lack or excess of jurisdiction. The petition for certiorari may only be filed by the stockholders of record representing the majority of the capital stock within 10 days from receipt by the Board of Directors of the institution of the order directing receivership, liquidation, or conservatorship. The designation of a conservator under Section 29 of this Act or the appointment of a receiver under this section shall be vested exclusively with the Monetary Board. Furthermore, the designation of a conservator is not a precondition to the designation of a receiver. The authority of the Monetary Board to summarily, and without need for prior hearing, forbid the bank or quasi-bank from doing business in the Philippines as provided above may also be exercised over non-stock savings and loan associations, based on the same applicable grounds. For quasi-banks and non-stock savings and loan associations, any person of recognized competence in banking, credit, or finance may be designated by the Banco Central as a receiver. Anti-Money Laundering Act. Authority to inquire into bank deposits. Notwithstanding the provisions of Republic Act No. 1405, as amended, Republic Act No. 6426, as amended, Republic Act No. 8791, and other laws. The AMLC may inquire into or examine any particular deposit or investment, including related accounts, with any banking institution or non-bank financial institution upon order of any competent court based on an ex parte application in cases of violations of this Act, when it has been established that there is probable cause that the deposits or investments, including related accounts involved, are related to an unlawful activity as defined in Section 3(1) hereof or a money laundering offense under Section 4 hereof, except that no court order shall be required in cases involving activities defined in Section 3(1) paragraphs 1, 2, and 12 hereof, and felonies or offenses of a nature similar to those mentioned in Section 3(1) paragraphs 1, 2, and 12, which are punishable under the penal laws of other countries, and terrorism and conspiracy to commit terrorism as defined and penalized under Republic Act No. 9372. Bank Secrecy Law. Section 2. All deposits of whatever nature with banks or banking institutions in the Philippines, including investments in bonds issued by the government of the Philippines, its political subdivisions, and its instrumentalities, are hereby considered as of an absolutely confidential nature and may not be examined, inquired, or looked into by any person, government official, bureau, or office, except upon written permission of the depositor, or in cases of impeachment, or upon order of a competent court in cases of bribery or dereliction of duty of public officials, or in cases where the money deposited or invested is the subject matter of the litigation.